My name is Kara Brimmer. Griswold, Roe, and Casey were all incorrectly decided. I'll discuss each case separately, ending with Roe. In Griswold, the court overturned a Connecticut statute banning the use of contraceptives under the argument that the institution of marriage is sacred and that the married party's right to privacy, specifically regarding the use of contraceptives, should be protected. I believe most reasonable people would agree that preventive measures fall within the scope of privacy rights. The issue arises, at least in my opinion, when the contraceptive kills the cell that forms when the sperm and egg meet at conception. I work for the post office as a relief carrier and use my own vehicle. I certainly don't want to hurt anybody, so I use safe driving techniques to ensure my safety goals. But if my techniques are insufficient and I cause an accident, my position with the post office will be terminated. Please forgive my unusual comparison, but this is the way I see the right to privacy. Married couples, and I'm using the Griswold fact pattern here, married couples have every right to take preventive measures when they engage in sexual activities, but if their measures fail and the wife becomes pregnant at the point of conception, the cell should be considered an individual person and should receive due process protection under the 5th and 14th Amendments. I'll discuss this concept further when I talk about Roe. But in summarizing Griswold, I believe that the court erred when it failed to acknowledge the right of the unborn child as a person eligible for due process protection against contraceptive measures after conception. Casey reaffirmed Roe, which I'll discuss in a moment. One particularly onerous aspect of this case was the court's unwillingness to change its position because such a change might make it look weak. But in this case, the court cites cases where it reversed prior opinions, so this argument is completely without merit. And finally, the court's decision in Roe v. Wade was also incorrect. Using the Griswold right to privacy to use contraceptives, the court went further and permitted abortion procedures. This is incorrect on a number of levels. First, the court at one point tried to employ science to show that the mother's health was at greater risk during certain points in the pregnancy. However, science also says that at conception, a single cell forms. On the one hand, evolutionists point to single cells as the origin of all life, and on the other hand, a court gets to decide that the single cell is of no value. If the court wishes to use science, it should use it on all aspects rather than picking the most favorable. Second, the court uses a textual approach to argue that most references to persons in the Constitution refer to postnatal people. However, the court later states that during certain trimesters, states have a right to protect the unborn life. This protection violates the court's argument that the prenatal period is not protected. In my opinion, this inconsistency with the textual argument shows that the court knew the textual argument was incorrect. The justices were Lochner-ing, using their own social perspectives to change the law rather than adhering to the true meaning of the law. Third, at one point, the court refers to the importance of protecting the mother's safety because if abortions are illegal, she will find some unsanitary, potentially dangerous way to have one anyway. However, the court also permits a ban on abortions during the 3rd trimester. This is another double standard. If the woman's life is not at stake, but she decides in the 3rd trimester that she wants an abortion when it's illegal, she may revert to the same dangerous operation that the court claimed it wanted to avoid in the first place. Its circular reasoning is ill-considered at best. Fourth, the court refers to the pregnant woman as a mother, but it's an irrefutable fact that you can't be a mother unless you have a child. This slip further demonstrates the court's hypocrisy. Fifth, the court points to viability, or the unborn baby's ability to live outside the womb, as a point of distinction that permits constitutional protection. However, this is a subjective standard that, if it's applied to the general population, could cause grave consequences. There are people of all ages who need machines to help them survive, whether it's for dialysis for kidney issues, or ventilators for breathing problems, or pacemakers to keep your heart beating. The need for external assistance for survival under Roe's viability standard would be devastating. Of course, we all know the Roe standard doesn't apply to the general population because it fits under the privacy standard, but this at least helps to show that using viability to determine the baby's value to the state is ludicrous and dangerous. Thank you very much.